National Association of Worksite Health Centers Annual Forum Day 2. Hope you all had a pleasant evening and dinner, and some people enjoyed themselves over with productivity at the NSK Roundtable. That was good times. A lot of us had dinner in interesting places. I hope you got to walk them all. You know, there's no tax on clothing or shoes, so take advantage of it while you're here. I don't know, there's a whole list of stuff here on the mini. If you go to the tax page of Minnesota, you can see the things that are exempt or not. So take advantage of it if you can. All right, so today we have a great half-day program for you. Again, I encourage you to visit the exhibitors, finish up the bingo cards. We are going to call the winners after the first grade today, which will be at 10:15. So please finish these up, turn them into registration, and then we're going to actually poll and name the winners. You must be here to win. So we're planning on having everybody here. Also, don't forget that for questions today, you can fill out the note card and just hold it up, and one of our staff people will pick it up if you have any questions. Or you can text me at 847-606-5527, and we'll try to get to all the questions that we can. Lastly, as I mentioned at the start yesterday, all of our packets got lost in the mail, which included the evaluation forms. And I know everybody just loves sitting down, looking at those evaluation questions, and filling them out, and putting in your comments. Well, you still got to do it. We're going to email you today a link to the evaluation form. We ask that you fill those out. For those speakers who you've heard yesterday, and as you can today, we are giving a prize for, we're going to do a random drawing of the evaluation form, so there's something else that you might want to consider there. All right, with that, let us begin. So our first session is regarding legal issues and legislative issues impacting worksite health centers. We have three wonderful speakers, experts in the field, who will be giving those perspectives. And so I'd like each of them to introduce themselves, and then we'll go into it. So, Melissa, would you introduce yourself, please? It's on.
It's on. Oh. All right, good morning. I'm Melissa Bartlett. I'm Senior Vice President of Health Policy at the NAWHC Industry Committee, otherwise known as ERIC. If you're not familiar with ERIC, ERIC is a trade association headquartered in Washington, D.C. We represent the largest employers in the country from the lens of their self-funded employee benefits offerings, both in the healthcare and retirement space. We have the pleasure of working with Liberty and NAWHC through coalition efforts around pushing forward legislation to provide better access for many workers and their families to worksite health centers. And I'm very pleased to be part of the conversation today. Thanks, Larry.
Thank you, Stephanie.
Hi, I'm Stephanie Eckerly with the law firm of Creek Duvall, and I mainly practice in the healthcare, regulatory, and transactional space.
Thank you. And Stephanie is Secretary of the NAWHC Board as well. Barbara?
Good morning, everyone. I'm Barbara Zavala, and it's my first time here. Not to Minneapolis, but to this conference. And I wear a few hats. One is I have my own law firm, Center for Health and Wellness Law, so I've been doing that for the last 9 years or so. So I do a lot of work with wellness types of issues from the legal side of things. And then I also teach full-time at the University of Missouri, Kansas City, and I'm a health law professor there on tenure track. So I'm going to be talking about some of the things that I see as a wellness lawyer and some of the things I'd like to see kind of go into the field. So thank you.
Great. So this is your opportunity to hear from some of our leading experts as it relates to laws and regulations relating to worksite centers. Melissa, we're going to start out with you. So please.
Great.
So this is, I don't know if you want to describe ERIC's and activities here or not.
Sure, absolutely. I guess we'll start off with the Employee Access to Worksite Health Centers Act. I mentioned, Eric is working with NAWHC's Fair Market Value Collaborative to reintroduce legislation that, quite frankly, has been out there now for a couple Congresses, at least on the House side. We're encouraged that there is bipartisan support to date, both in the House and it appears to be in the Senate as well, to reintroduce legislation. At this time, we have commitments from in the House, reintroduction by the lead bill sponsors from last Congress, who are 4 strong Republican and Democratic members that sit on the Ways and Means Committee, so that's the committee of jurisdiction over health savings accounts and high deductible health plans. And they are finalizing the draft at Legislative Council. I hope that they would have introduced the bill today. That was the target. Unfortunately, they're still working out some of the details, so stay tuned. I was excited for a big reveal, but unfortunately, no.
So let me just take a minute for those who aren't familiar with the fair market value issue. The IRS code says essentially if an employee uses an on-site clinic defined as it was in COBRA, which is offering essentially first aid triage. If the employee uses an on-site clinic for more than first aid triage, they must pay a mandatory copay, which is called a fair market value fee. And that could be anything that the employer comes up with. Could be $50, could be $100 or more. Or they lose eligibility for contributing to their HSA plan. And so we created the Fair Market Value Collaborative of employers and vendors and providers and consultants and other business groups. We have over 20 organizations, and we are trying to change the law, which essentially would be a change in the IRS code related to health savings accounts, which would move what's currently done in Worksite centers from behind the deductible to in front of the deductible, similar to the preventive care listing that is available now. And so Melissa has been leading the effort with our ERIC colleagues to meet with various legislators and their staffs to try to get them to support a bipartisan bill on this. And we have, it's already been submitted to the House and the Ways and Means Committee, and we're trying to get bipartisan support in the Senate. So just to give everybody a foundation for it.
And in the Senate, we can say that Senator and now presidential hopeful Tim Scott from South Carolina has agreed to lead the bill for the Senate companion piece, and we also have a number of Democratic senators who are interested in pairing up with him to introduce it in the Senate. So we're quite excited that there could be opportunities for movement this year. I do want to manage expectations though, because I think this is a good time to transition to the congressional outlook part of this slide. As you know, there's been a lengthy congressional recess. Senate returned this week. The House is still out. It comes back on Tuesday and has 11 days that they're in DC and in session until a potential government shutdown after September 30th. That is 11 days for a House where Speaker Kevin McCarthy has a margin of like 4 votes to work with to get a deal on funding the government and a whole host of must-pass items that expire September 30th, including things like the FAA reauthorization, flood insurance, the health centers funding, Medicaid dish payments. I know I'm missing a whole bunch, but there's a whole long list. And obviously, foremost of mine is whether or not the government will shut down. So when I say we're encouraged that we have, what looks like considerable support for advancing our Worksite Health Services Act this fall, the ability to do so this month in this setting and this backdrop of all what are the priority issues right now, more globally, and what is in the front of minds of members of Congress. It looks a little less dim for the bill to happen immediately. So what we'll be looking at are things like health extenders, tax extender bills, things that may come after September 30th. There's a lot of unknowns right now about what's going to happen before now and the end of the year. Congress typically has some kind of year-end packages where they tie up loose ends to keep the government funded well into this fiscal year past the end of the calendar year. There could be these quote mini buses you're reading about, or omnibuses of packages of appropriations bills. There could be small tax extender bills, or like I said, Medicare or Medicaid health extender bills that have to be done by the end of the year. Those will present opportunities where if we stay close to the committees of jurisdiction, that's the Ways and Means Committee, like I mentioned, which is good for us. Our bill sponsors all sit on that committee, or the Senate Finance Committee, which again, good for us. Senator Tim Scott sits on that committee. Hopefully we can, work to get our bill included in any of those moving vehicles. And a word, just so you know, this is probably a good time to be trying to advance your legislation, because the time is right on HSAs. It's not going to be perfect time because there is still a very political issue on Capitol Hill for a number of members. There is significant pushback by Democrats around whether HSAs benefit the wealthy disproportionately to middle or lower income workers, and whether it's more of a tax shelter type benefit, as that's sort of how it was characterized when they were first created. But there has been significant growth in the use of HDHPs and HSAs since they were first created, and use of them as an important tool for patients to mitigate their out-of-pocket liabilities in the current environment. And so some Democrats, not all, understand that value. And so right now, this is actually the 20-year anniversary of the HSA, because it's the 20-year anniversary of the Medicare Modernization Act, which included the creation of the HSA. And the chairman of the Ways and Means Committee, Jason Smith, has been very interested in looking at ways to modernize patient access to how they use their HSA dollars, what are the regulatory flexibilities they need, how do you bring it up to today's access to patient care. And so this policy really is right for that conversation, and that's why he's very interested in this bill. We're also working with him in tandem on other areas that are probably maybe of interest to you. Our lead co-sponsor of our bill, Congressman Brad Wenstrup from Ohio, is also the lead sponsor of the Chronic Disease Flexible Coverage Act, which also falls under the jurisdiction, of course, of the Ways and Means Committee. And that bill codified the IRS guidance around, the coverage of chronic care, primary care tools. And from 2019, and again, the chairman, Jason Smith, brought it up for a vote in the committee, and it passed with bipartisan support, and a pretty good number of bipartisan members voted for it. So in tandem, when you look across that bill and our bill, access to primary care services really will be enhanced compared to maybe where HSAs were when they were first created 20 years ago. And then last but not least, I would mention telehealth. There are two bills that, again, the committees, both the House and the Senate, are looking at in terms of, one, extending the current telehealth flexibilities that are in place right now. Those telehealth flexibilities are extended under last year's end of the year bill package through 2024, so through the end of next next year. This would make those flexibilities permanent. Another measure would allow for the use of telehealth only plans, allow employers to provide telehealth only plans as an accepted benefits. And so we're encouraged that, again, Congress is taking a very smart look at how to reshape the access for patients to how they use their HSA dollars to offset their costs. I would be remiss if I didn't tell it, and I think everybody in this room probably does, but I myself, I have HDHP, not necessarily by choice, but when I looked at my offerings, almost everything really was an HDHP. It was just a matter of scale. How much high deductible was I going to be charged? So I think 20 years ago, the people thought of HDHPs as a way to get people to take more accountability for their healthcare spending and then wrap an HSA around. Now, the world shifted, and as we now know, most people basically are faced with some form of HDHP as their coverage. And so their ability to use an HSA really is become almost like the FSA of years ago, how they can plan for their out-of-pocket exposure. So we're hopeful Congress gets that point and allows for the regulatory flexibilities for many, many Americans, low, middle, upper income Americans to take control of their health care.
Thank you, Melissa.
Yep.
Thank you very much. So now I'd like to ask Stephanie to talk about some upcoming or trendy legal issues, and then we'll go for other things. So, Stephanie, what are some of the legal issues that providers and employers should be thinking about as it relates to artificial intelligence and ChatGPT?
That's one of my favorite things to talk about because it's new and fun. If you want to talk about regulatory compliance and starting your clinic, we did that yesterday, and happy to talk about that offline. But for ChatGPT, I'm working with a few clients right now that are incorporating this into their software from a healthcare perspective, and some health systems and even people in the employer space that are rolling out policies about how ChatGPT can be used. And some are saying, no, it can't be used at all, and we're completely prohibiting it in the workforce too. So as it relates to you guys, I think what you're going to see coming up is ChatGPT and OpenAI used in what they call clinical decision support software. And this is going to be regulated by the Office of National Coordinator. So they already have a proposed rule out, accepted final comments in, I think it was June was the deadline. And then you also have, FDA, FTC, GINA, all these other laws that apply. But this could be for, you'll see it in clinical guidelines in your software. I've seen it rolled out for diagnostic support tools, documentation templates like return to work letters. And a couple of the big things I think you guys need to be thinking about if you're working with vendors that are using OpenAI in software, or if you're going to allow your practitioners to use it, or employees. A couple of things. One is discrimination is something we're really, really worried about. I heard an interesting story from a healthcare system that during COVID, when they were looking at allocation of resources, we're short on ICUs, pulmonary and critical care docs, PPEs, they had a tool where you could basically put in where the person was from, race, ethnicity, different things, and it would basically give outcomes for survival and allocation of resources, all based on AI. Well, it's loaded with bias and discrimination, right? Because you're not taking into account anything related to that patient, any of the care that they could receive. So this is one of the big things the government is trying to regulate right now, is looking at data sets that incorporate both historical bias and then using it for certain classes that could lead to discriminatory outcomes. And so the more I've gotten into this with clients, you can actually see some of this really play out in the real world, and that was kind of I think, large example there where we were looking at, rate of survival based on zip codes and ethnicity, but it shows how AI can be very skewed and really affect patient care then if you're going to allocate resources based on that. The other one, of course, is HIPAA. We're seeing a lot of HIPAA issues there as far as PHI. And so some of the policies and procedures we're working on for clients, and if you haven't used ChatGPT, you guys should try it. It's really fun, but it also pushes out a lot of fake results. So just know, I've seen fake medical journals come out, fake cases. You guys, if you've used it, it's good and bad. But, we're encouraging all healthcare clients and employers that run on-site clinics to put a policy into place, because even if you don't think your clinicians are using it, my guess is they probably are, or they will be. So no protected health information in there, no code, IP, trade secrets, that's a really big issue. Don't create items that you want copyrighted in there. So we've had clients that have created really cool logos or videos and they want to get a copyright, or they work through ideas on ChatGPT and want to get a patent. Probably not going to happen based on the new laws and cases that are coming out on that. So when you think about your employees' creation of a work product, and I think the biggest thing for healthcare providers with the AI is really just having terms around when it can and can't be used. So for example, not using it to replace your independent medical judgment. I saw a demo, I was talking about this at dinner last night, it was a really cool one with an oncology group, and they had a really patient that, very rare form of cancer. They put it in ChatGPT. Oncologists actually got advice saying, you should really consider using this drug, this treatment with it. Oncologists hadn't thought about it. Called, I don't know if it's Cleveland Clinic or one of the big institutes, and they're like, oh, that's actually a really good idea. We should look at that, right? Then we saw with a cardiologist that same day who put in something, and it spit out all these journals and things they should be doing from a clinical standpoint. And it wasn't the American Heart Journal, but something like it. It was a fake journal. The citation was wrong. Everything was fake. So it's two really stark examples of why you should never use it in place of clinical decision making or medical judgment. We've also seen a lot of healthcare providers try to use it on the billing and coding side and for audits. Again, I wouldn't rely on that for billing and coding and audits, but it could be a useful tool. Creation of medical records by a provider. We've had this come up with clients too, where they're actually trying to put in there and take what ChatGPT did, copy and paste it into the medical record, as opposed to them have to do everything. Not okay, not allowed, all kinds of violations of Medicare and Medicaid if we're billing, which I know people in this room don't do. It's still not great. And so it can be a really cool tool, but I encourage you guys to have policies and procedures for it and really think about ways that it may be used by your employees, because as much as people are thinking no one's going to use that, I had another client that made a video and took their CEO's voice and fed it into ChatGPT, so the CEO voiced over this video and it sounded like him, so they're sharing it, and he wasn't thrilled about it. And so that was something that's like, we can't create it. We would have never thought about putting that in a policy and procedure, right? So I think it's one of those things, there are things that will come up and it's like using your good judgment. And the other areas we've seen is too, if you do have someone who's using it, you don't have those protections in place, how you as the employer could be liable under vicarious liability and different theories too. So I think it's really exciting, but I think it's something that all of you in this room should be thinking about, and thinking about the regulations that are coming out, thinking about how your employees are going to use it, and really thinking about how your vendors are using it too. So everyone in this room probably uses an EHR, or their vendor does. Is it being used in the EHR? Is it a certified health IT? Are they following proposed rules and new rules that may be coming out from ONC on how that can be used in there? So,
Great, thank you. Stephanie, we can about that 1 minute for you. What are some of the enforcement priorities you see coming in 2024 from HHS to impact Worksite centers?
This is another fun one. So I was just at a conference and we got to hear the director for OCR speak with the Indiana Attorney General. And it was Doug Sputnam who's in charge of our privacy and security. And if you're in Indiana or near Indiana, we have a very aggressive AG's office. They just love enforcement actions and press releases. So there are really two areas right now that we're concerned about, I think, for you guys. And one of them is tracking technologies. I don't know if you guys have seen all the announcements about this, but HHS and the FTC, Federal Trade Commission, are very, very active in this area. And on September 1st, they actually sent letters to hospitals and telehealth companies and other healthcare providers about tracking technologies. It's a 350, 80-page document, and you can actually see all the companies they sent letters to. I don't think anyone in this room is on it. I'm not all the way through it yet, but I will have a list by Monday. I know some of your vendors are on it. I know some of your telehealth companies are on it. I don't know if these letters were sent because they're worried about it or it's just a, hey, be aware of this. But basically, if you're using Google Analytics or Facebook, Meta, some of these others to get data on your website, this is going to be a big issue. And what's really interesting, I think, for this industry is it is going to be an issue for both covered entities and non-covered entities. So even if you're not a covered entity, which I know some of the telehealth companies and vendors you work with, cash pay, they say they aren't doing standard transactions, this is still going to apply to you due to FTC enforcement and Attorney General enforcement. But basically, even if you have no relationship with a patient and you're a healthcare provider, and that patient comes to your website and fills out a form, fills out I've seen a prayer request form have this, fills out they want information about one of your programs, maybe a diabetes program. If their information, including their address or IP address, even IP address, goes back to a third-party vendor like Google Analytics, it is considered a HIPAA breach. So even if you do not have a relationship with that person. And what was really interesting was Doug Swetton of the Indiana AG said they are literally going out to healthcare provider websites, even non-covered entities, and looking at the way they are tracking to start enforcement on this. And we should see enforcement from the state AGs and HHS, I think by end of this year, especially with these letters coming out. So medical record numbers, a date of appointment is going to be it. Lab requisition forms, if you've got a lab form that's filling out. And what I found, and I've just been involved in this very recently because it's new, is there are some cyber companies that are actually going out and looking to see what data goes back, and it's shocking the data that's going back to Google Analytics and Facebook. That I don't even think people know about it, because what I'm seeing is a lot of times the marketing department is the one that's running your websites. They're the ones that are putting these into place, and they're not thinking about that. And a lot of these analytics were put into place, 5-10 years ago with Google Analytics. So at the time, we're not thinking that a patient that you have no relationship with, if you're getting their IP address, it's a HIPAA issue. And so this is something that I think you need to be thinking of. The last thing on this too, if you use apps, so a lot of you guys use apps, I feel like there's a ton of really cool solutions. We saw a lot of cool ones in there. Even if you have a third-party developer make your app and you're not using that information for marketing, if it's going back to that third-party developer through tracking technologies, it's also a HIPAA breach. And so this is something I think that's probably going to be the #1 enforcement action you're going to see here coming up, especially with all these letters going out. If anyone wants me to send you that big packet of letters and the HHS information and FTC, I'd be happy to. The other big one that they made a huge point about that they're going after with covered entities and non-covered entities is for discrimination on the basis of disability in healthcare. So maybe you have an employee that goes to your health site clinic who has visual issues, they can't see well. They get a statement basically about their HSA payment or a charge or a lab result, and it's not a large font. That could be considered discrimination, and that's the example that HHS used. And so just thinking about all the different ways, and in fact, her business card actually had Braille on the back, which when she was talking about it, was kind of cool. I've never seen that before. But so I think that's another one that I personally really has not been on my radar lately that I think you guys should all be thinking about as it relates to the way you're treating employees, independents. I know employers are great with EOC and ADA, but I don't think we've thought so much about the healthcare angles of discrimination.
Thank you. That's great. Barbara, let me ask you some questions in general. What are some of the lawsuits that may be of interest on site also?
Yes, thanks for that question, Larry. And it actually segues nicely with Stephanie just talked about the last piece about discrimination. There was a case in 2021 out of North Carolina that I don't know if anyone had heard of, but I recently kind of stumbled upon it, and it was Manus versus Village of Pinehurst. So this was a municipal employee lawsuit against their employer, the Village of Pinehurst. And this village had hired a third-party vendor to run a wellness program. And I know a lot of wellness programs might be run out of on-site clinics, for example. And this third-party vendor was going to conduct all the biometric screens, and they developed the forms, the consent forms that were going to be signed by the employees. And the contract between the village and the third-party vendor had an indemnification clause, a hold harmless clause, and a requirement that a third-party vendor be responsible for all compliance, basically, with federal and state rules and everything else. So the employer was delegating all that compliance stuff to their third-party vendor. And the employee who brought the lawsuit felt that he was being forced to participate in this biometric screen. And he didn't want to. So he complained to his supervisor and said, I don't want to participate in this. And he ended up being fired. So he sued under the Americans with Disabilities Act and Genetic Information Non-Discrimination Act because under both of those laws, a participation in a wellness program that's collecting employee health information must be voluntary. And the GINA claim, you know, there were employee family medical history questions as part of the screening. So that's how we got the Genetic Information Non-Discrimination Act involved. Well, you can imagine the employer was furious, so they countersued their third-party vendor. And the third-party vendor tried to move to dismiss their complaint against them, even though there was a provision in the contract that basically put the burden of compliance on that third-party vendor. And the court quickly dismissed the case against the third-party vendor because this was a discrimination-based claim. So GINA and Americans with Disabilities Act are federal civil rights laws. So the basis of the claim is that you are discriminating against me because I don't want to participate in this wellness program. And the Supreme Court, U.S. Supreme Court, has already, in past cases, said under other federal civil rights laws, like the ADA, like the Title VII, any federal civil rights law, that you, as whoever the responsible party is under the statute, the covered entity is what we call it in the statute, which in these employment discrimination laws is the employer. They are ultimately responsible for the compliance and for any allegations of discrimination. And even if you try to offload that responsibility to a third party, the federal civil rights laws will override that contractual provision. So this case really was saying, like all the other federal civil rights laws that have already been decided, that you can't, as an employer, offload your responsibility to a third party for compliance. GINA also is one of those federal laws. So that's why this third party vendor was excused from the lawsuit. And I think the parties ended up settling, so this was a couple of years ago. The other lawsuit that I just wanted to bring to your attention, which I found interesting because I work a lot in this space of data collection of employees and lawsuits that kind of come from that. There have been a number. I assume in past conferences you probably talked about them. The AARP has been very active in bringing these lawsuits on behalf of employees. But this one was brought in February of this year against Quad Graphics. It's a class action. And so there's been no outcome yet. The complaint was just filed in February of this year. And what's interesting about this one is that in conferences in past where I've spoke, I've told my audience members, like, if you want to avoid the Americans with Disabilities Act voluntary requirement, you want to incentivize your employees to participate in these programs that you're offering as wellness. But you want to collect their data through biometric screenings or health risk assessments. One way to make it seem more voluntary, seem less of privacy invasion, which is usually the complaint by employees, is to have them go to their doctor. So incentivize them to go to their doctor, go to the on-site clinic, and get the screening done there, because presumably there's a bit more trust or insulation from employers in viewing your private data, because that's usually the impetus for these lawsuits, is the employees feel like their privacy rights are being infringed. Well, in this case, that's what Cloud Graphics did. They said, we want you to go to your doctor and have them fill out with you this 2-page screening form. And this plaintiff, who's again filing for a class action lawsuit, said that's still invasion of her privacy, and so she, the penalty was if you didn't fill this out, you would pay $1,800 more in your health insurance premium a year. She asked for a waiver. Can I be waived out of having to fill this form out with my doctor? And they said no. The employer said no, you can't. You have to. This is an initial step. And then once you complete that, there are alternatives on how you can avoid the $1,800 premium hike. But this is a first step. So she is suing under the Americans with Disabilities Act, even though the process was to go to your doctor. That's why I find this case really interesting, because usually it's an on-site screening at the employer site, and it's the employees just don't like that. But going to their doctor, usually they feel a little better, but not so in this case.
Can I jump in on that one too?
Sure, go ahead.
So real quick, and that's, when we talk about risk to on-site clinics and employers, I think the plaintiff class action bar is super aggressive right now too. So on the tracking technologies, there are literally law firms out there that are going through and trying to find this. On the ADA claims, I mean, we are being flooded with class action complaints that are honestly really frivolous, and same with a lot of AG complaints. And so it's something too that I think from a risk standpoint, just be thinking about that, even if it's not a regulatory HHS risk. It's a really good point of what we're seeing and really all of healthcare too.
Okay, Barbara, you also asked, should health clinics offer ketamine treatment for mental illness?
Yeah, ketamine. Yeah, so part of my practice is helping a lot of startup companies from all kinds of areas of wellness. Wellness is like the Wild West. It is not regulated in the same way as traditional healthcare is, and so it's interesting. And one thing that I've been seeing in the last month, really, is interest in ketamine, using ketamine for depression. I'm sure you all read the news and hear about how there's just this widespread crisis in employee mental health and well-being, and a lot of depression and anxiety and post-COVID stuff. And so behavioral health is definitely, there's an uptick in interest from all kinds of different players in the health space. And there's been a lot of studies recently on the use of ketamine to treat other treatment-resistant forms of depression and mood disorders. And so a lot of these startups are kind of jumping on this bandwagon. They're either opening up standalone ketamine clinics, or I've just learned of one startup that's getting a lot of investor funding to actually approach employers, self-funded employers in particular, to offer ketamine treatment to their employees as a behavioral health treatment. And ketamine is a psychedelic. So let me just back up for a moment. Ketamine is a psychedelic. It has actually been approved by the FDA. It's been used for anesthesia purposes for a long time. It's a generic drug. So, but it's been lately being used off-label by MDs and nurse practitioners for through IV infusion to treat depression that cannot be treated with other conventional methods like antidepressants and therapy. And it's been getting pretty good results as far as the studies that have been out. There's a lot of studies going on. And so the interest is climbing, and there's interest in other psychedelics too, but those are illegal, whereas ketamine is legal. It's just to be used as an antidepressant, I guess, is an off-label use. So I bring this up because I know that there are people out there who are starting to create businesses around this and approaching employers. So if you haven't been approached yet, I think it's something that's only a matter of time and you will be. And asked to kind of incorporate this as part of your treatment plan or benefit offering to your employees for mental health issues.
Great, thank you. Let me ask you one last question, Barbara. We talked a little bit about social determinants of health. Is this something for Worksite centers?
Yeah, this is something that I'm kind of like on a mission for. You know, this is more from my faculty hat here. So social determinants of health, things like housing and domestic issues and discrimination and things, environmental factors that all contribute to a person's overall well-being. Because, you know, at the end of the day, the whole point of offering health benefits and wellness services to your employees is to improve their well-being. I know also to reduce costs, but that kind of goes hand in hand. And so, you know, a lot in the healthcare sector, hospitals, clinics, you know, they are really being pushed and encouraged by the government to look at social determinants of health and include that as part of their service offerings. And to address that concern, there in the healthcare sector, there's these things called medical legal partnerships. So to help address those social determinants of health, hospitals and clinics will partner with public interest law firms, law school clinics, and other pro bono lawyers usually to have as a referral source. If a patient comes into your clinic and, you know, is complaining about things that aren't, you know, in your wheelhouse as a provider, but it's definitely playing a role, like maybe they're, you know, they're getting kicked out of their apartment, or maybe they're exposed to asbestos, or maybe they're, you know, unable to get certain benefits, or they're facing domestic violence or something like that. You have with this partnership a resource that you can refer these individuals to and help with that, so that ultimately they can actually get on the right track and improve their well-being. Now, my proposal is to create something similar in the employer space called wellness legal partnerships. That it's basically the same kind of thing, but this time in the employer sector. So on-site clinics would be a perfect place for this partnership to occur with legal, social work kind of partners to help address those social determinants of health.
Thank you. We should have clearly spent more time allotted here. I want to take questions from the audience now. We just have a couple of minutes left.
Larry, can I just do
Sure.
one quick, two quick plugs? One quick sort of response plug-ish to Barbara's comments about the cabinet is for everyone to take a look at the tri-agency, tri-departments proposed rules implementing with PIA and the Consolidated Appropriations Act, the changes to the mental health parity federal rules. Very carefully. I know, Eric, we are working with our member companies, and when you submit a comments are coming up due October 2nd, but it's really a very complex rulemaking and set of proposals that will completely change the landscape of how employers and plans approach mental health parity and be held accountable for mental health parity. And it makes me wonder how these startup companies are going to approach integrating. So would love to hear any of your feedback in any of that. So I'll connect with Larry and others about that. But that aside, my other pitch is I would be remiss if I didn't ask any of you who may have a presence in the states of Arizona, Rhode Island, or Wisconsin, if you would like to participate on a call with the staff of Senators Sinema, Whitehouse, and Baldwin, respectively. Next week, there are calls set up that Larry and others in our Fair Market Collaborative will be on with the staff to make our pitch that any of those 3 Democratic senators might want to get involved with our legislative effort in the Senate. We'd love to have you. We'd love to have any data you have about, the patients that you serve in their states and the services that you provide. So just contact, Larry if you'd like to participate in those calls next week.
Great, thank you. I'm going to ask some questions from the audience, just very quick responses. Stephanie, do you think AI will be introduced in the EMRs?
It already is
It already
being
is.
introduced today in EMRs, so yes, in fact,
Use
it
it
may
back
be
to
in it
phone.
and you won't
Stephanie,
know.
just like-
Oh,
Yes, it's already being introduced in EMRs. You may be using it and not even realize you were using clinical decision support software, and ChatGPT will be incorporated in EMRs. OpenAI, the company that owns ChatGPT, is already in the works talking to EMRs about this. So yes, 100%.
Yeah, can you give an example of services that will be enabled by the CDMA? I don't know what CDMA is, never asked the question.
I don't know what that is, so if anyone wants to tell me or...
Chronic Disease Management Act.
Oh, I could get back to you on that one after I research it, but I don't know the answer.
I do have a list here, but in the interest of time, do you want to go to the next question?
No, why don't you go ahead, very quickly.
All right, just give me 1 second. It's in my papers.
Okay, while she's looking quickly, it was noted by a member of the audience, Academy nasal spray as a treatment for refractory depression is FDA approved.
Yes, it's S-ketamine, and it has just gotten FDA approval. And it, unlike ketamine, which is a generic, that is so that's going to be a lot more pricey, just so you know.
Okay, was there one question? All right, I'll take Melissa, why don't you connect with Dr. Musi afterwards? Or you want to quickly say it?
The list from the IRS are things like, for example, beta blockers, blood pressure monitors, inhaled corticosteroids. I'm not a professional. My doctor's sister would kill me right now. Insulin and other glucose-lowering agents, peak flow meters, glucometers, A1C testing, low-dense lipoprotein testing, statins, SSRIs. Basically, when you consider what are the primary care diseases and conditions, those primary care products and tools that would be associated with the asthma, depression, heart disease, liver disease, etc.
Thank you very much. Let's thank our panel very much. And I would ask that the panelists to be available up front here so people could ask additional questions. That would be great. Thank you. Let's have the next panel come on up. We're going to take this next session. It's going to be in 2 parts. This is how to measure the quality and value of a Worksite Health Center. And so we're going to start out by having a series of panelists talk about quality as viewed through accreditation standards and the development of quality studies. And then following that, I'm going to do a short presentation on measurement strategies in Worksite centers. So if everyone will come on up. Jennifer, you want to come on up?
Yep.
Let's just have everybody introduce themselves first. And so Dennis, why don't you start?